Hi, everyone. This is Ashwin Phatak, Appellate Counsel at the Constitutional Accountability Center in Washington, D.C. Today, I listened to oral arguments in Collins v. Mnuchin, a case in the Supreme Court concerning the Federal Housing Finance Agency, the FHFA. Now, this agency, a lot of people might not know about, but it actually is quite important. The FHFA was created during the financial crash and the crash in the housing and mortgage market back in 2008 in order to regulate and oversee Fannie Mae, Freddie Mac, and other government-sponsored entities that work in the mortgage market, in the mortgage marketplace. And the FHFA regulates these entities, and sometimes the FHFA can step in to be the conservator or the receiver of these entities when they're at risk of failing or otherwise in trouble. And so that's basically exactly what happened in this case. For those that remember, back in 2008, 2009, Fannie Mae and Freddie Mac were basically on the brink of failing, and the federal government stepped in and basically bailed them out. And how this worked was that the FHFA acted as a conservator of these entities and entered into an agreement with the United States Treasury Department, in which the Treasury bought a whole bunch of shares in those companies, in Fannie and Freddie, and in return got to reap any future profits that those companies made. And in fact, they ended up, in the years after the housing crash, to make a good deal of money, and most of that money ended up going to the Treasury under this agreement. So various private investors in Fannie and Freddie ended up filing suit, challenging that agreement and the basic scheme in which profits from those companies went to the Treasury Department in court. And they brought a few different arguments. One set of arguments concerned the statute that governed the FHFA. And the questions in those statutory questions basically concerned whether or not any actions of the FHFA as conservator could be challenged in court at all under the statute. But in addition to those statutory arguments, one key argument that these private investors made was that the FHFA itself was unconstitutional in terms of how its director operated. And this raises a question that the Supreme Court has been taking up a number of times in the past few years, and in fact, really over the past few decades. And this is the question of when you can insulate a particular executive branch official from the president's power to fire that official. And so the FHFA is one of a number of different departments and agencies, independent agencies in the federal government, where there's some restriction on the president's power to remove a particular official. In this case, the statute says that the president can only remove the FHFA director for cause, not for any reason at all. And this has been challenged under the Constitution on the theory that the president, given his Article 2 role of running the executive branch, must have the power to remove executive branch officials at will. And the Supreme Court actually took up this question last term in the context of a different agency, the Consumer Finance Protection Bureau, which is also led by a single director who had some who the president could not remove for any reason. And the Supreme Court said that that scheme was unconstitutional and that the president must have the ability to remove the CFPB director for any reason. And these private investors in Fannie and Freddie made the same claim about the FHFA, basically arguing that this decision of the FHFA to become a conservator of Fannie and Freddie and then enter into this agreement with the Treasury Department is void because the FHFA director was never unconstitutional in terms of the removal restriction. And the Solicitor General, who defends the United States in the Supreme Court, refused to defend the FHFA director's for-cause removal protection. And so the Supreme Court ended up appointing an amicus to brief that issue. And the Constitutional Accountability Center filed our own amicus brief in support of that court-appointed amicus in defense of the constitutionality of this removal scheme. And the basic argument in this case was whether, on this constitutionality point, was whether the FHFA could be distinguished from the CFPB. And in our brief, we made two different arguments about that. The first is that the FHFA has a much narrower focus than the CFPB. The CFPB, for those that don't know, is tasked with regulating sort of the entire consumer finance industry. And that can be, thousands of different companies, basically affecting everybody in the United States, and has the ability to impose fines and craft its own regulations in that entire sphere. The FHFA, we argued, and so did the court-appointed amicus, has a much more limited scope in terms of its regulation. It really regulates only these government-sponsored entities like Fannie Mae and Freddie Mac. And so for that reason, given its much narrower scope, perhaps a removal restriction is okay in this circumstance when it might not have been okay in the case of the CFPB. The other argument that we made is that these entities that the FHFA is regulating are government sponsored. So they're sort of quasi-governmental. Their charters are crafted by federal statute. And that's a little bit different than the CFPB, which is regulating purely private entities, basically any private company that's providing some kind of consumer product in the financial arena, credit card companies, loan companies, et cetera. So in both those ways, we tried to argue that the FHFA is different than the CFPB, and it need to be the case that this is an unconstitutional arrangement even though the CFPB was. In the argument today, the court didn't address this point in too much detail, but it didn't seem like they were very likely to agree with it. It remains to be seen. It's sort of hard to read the tea leaves from the argument, but I think while the distinctions are pretty clear between the FHFA and the CFPB, it's not clear whether the court was buying that those distinctions made a constitutional difference. It did seem like the more likely way that they might end up dealing with this case is to just say that at the time that the FHFA entered into this agreement, the director of the FHFA had been appointed in an acting capacity. So this wasn't somebody that had been confirmed by the Senate. And the court may say that acting officials actually don't have any for-cause removal protection. All acting officials, even in independent agencies, are removable at will. And for that reason, the court may choose to not even address the constitutional issue that the court-appointed amicus and our brief was addressing, and simply say that because there was an acting official in charge of the FHFA at the time this agreement with the Treasury Department happened, there isn't a constitutional concern in this case, and that would be a way for them to avoid the issue. So if you want more information about this case or to read our brief, you can check out that brief and more information about the case at our website at www.theusconstitution.org. And with that, thanks so much for tuning in.